All right.
Good afternoon.
Good afternoon. Welcome everybody to our seventh and final webinar of 2020. What a year. Very excited to wrap up the year of webinars with sort of a highly requested year-end to-dos on real estate and business. We started the year off with a COVID webinar Hamilton and I did back in June. Then we moved on to retail leasing and commercial leasing in August, and residential real estate in September, and then office leasing. And then finally a boundary line issues and title issues webinar. If you haven't seen any of those, we welcome you to go to our website and check in the news and insights page, and you can get all of those have been recorded if you're interested in sort of checking in on where we got this year. And today we're going to go over sort of our current state of affairs and orders. Then we're going to talk about wins and losses across the year. And then finally get into some year-end to-dos for business and real estate issues. So without further ado, my esteemed business partner and awesome attorney, Hamilton Gardiner.
Thank you, Imants. And it's interesting, as there are many things that we can say this year. If you asked each of us if we would be doing webinars this year in January of 2020, we would have given you a resounding no. But here we are, Imants and I, live and in person on this webinar. So thanks again for joining us and being a part of this. It's been an interesting experience, and we've really enjoyed it, and adding this to our efforts and connecting with clients and colleagues out there. And so I am going to start off, like I've done in other webinars, with an update as to the current moratoriums on evictions here in dealing with residential and commercial real estate. So I've done this a number of times, and there's been quite a bit of a debate. And if you're kind of in the legal community and represent landlords and businesses, you kind of you're in one group, and then you've got different groups more focused on the pandemic side of it. And there was a big debate today on actually the real estate listserv for the Washington State Bar Association about this, a lot of emails. But I think one of the listserv people summed it up pretty well. And it said that, you know, it seems that Inslee's goal in these moratoriums is the avoidance of a humanitarian crisis caused by the economic impacts of the pandemic. The goal is not to benefit tenants financially by burdening landlords financially, or at least it shouldn't be. The goal is really to prevent homelessness and people being kicked out in the middle of a pandemic and spreading the disease further. However, as is kind of my opinion, and I share this opinion, as did this person on the listserv, the current proclamation and the proposed statutes that they are going to be evaluating in this session extend well beyond this goal in trying to deal with the economic impacts. So where we are today is in Washington State, landlords and property owners are prohibited from, a notice of an eviction or seeking to evict residential tenants. No serving, enforcing, or even threatening to serve or enforce an eviction, period. Unless there is a significant and immediate risk to health, safety, or property of others, excluding COVID, which seems like the most obvious risk, but it has to be significant and it has to be immediate. Or the other option is if the 60 days written notice by the landlord's intent to either sell the property or to personally move into the property and use it as a primary residence. Statewide, those are the only two means in which you can try and evict somebody. On the significant and immediate risk to health or safety, I will tell you that is a high hurdle. I've rarely heard of a situation leading to that, but it's rare, but it can be done. So just seek legal counsel if you are going to try and invoke that exception. There's a prohibition right now on using unpaid rent as debt and trying to collect on that debt. Once the moratorium is over, theoretically, landlords could go try and collect on that debt. I think a lot of landlords and landlord clients of ours would know that seems very, very unlikely, but there is a current prohibition on that. You're not allowed to increase rents for residential or commercial tenants. On the commercial side, that rule does not apply to existing contractual rent increases. So in other words, if you have regular step-ups annually in your commercial lease, you can still do those. You're not allowed to have late fees or interest in Washington or in the city of Seattle. And in the city of Seattle in particular, this is going to go on for at least 1 year after the end of Mayor Durkin's eviction moratorium. There's also a prohibition on the retaliation for failure to pay, but you can communicate about the unpaid rent. Sending statements is generally okay. In the city of Seattle, the late breaking news from yesterday afternoon is Mayor Durkin unsurprisingly extended the eviction moratorium to March 31st, both on commercial and residential. This probably really has more to do with commercial than it does residential because of the winter ban on evictions in the city of Seattle, but it was expected from my vantage point that she was going to extend this. So in the city of Seattle, you're required to have offer repayment plans for non-payment of rent owed within the 6 months following the end of her eviction moratorium. There's a whole kind of process to what that looks like. So if you are looking to enter into an installment plan, make sure to contact an attorney and evaluate exactly what type of plan you're going to put on the table. 14-day notices to pay or vacate within 6 months of the termination order must include specific language. And there's also additional language that you need to include on all applications for rental properties in the city of Seattle. So on the commercial side, in addition to the moratorium on evictions, there is also for small businesses, you're unable to seek personal guarantees, I should say, to seek collection of rent on the personal guarantees on commercial properties for small commercial businesses. So again, it's a nuance to the rule just in the city of Seattle. If you are seeking to get repaid on some outstanding rent, just make sure you're evaluating that with your attorney. In King County for residential and small business tenants, again, no late fees, interest, and other charges through at least March of 21. You're going to need to do a repayment plan. And if the tenant refuses to do or to enter into a reasonable payment plan by the landlord, then this could be grounds for an eviction again after the moratorium. It's also a defense to an eviction if the landlord fails to offer a reasonable repayment plan. And then also residential rental agreements may not be terminated while on a repayment plan unless the tenant refuses or fails to comply with the repayment plan. So, or of course, if there's the immediate threat to health and safety of others. So needless to say, there are many current eviction and moratoriums in place. And if you are considering this or having a difficulty with tenants, or you're a tenant yourself, reach out to council, make sure that you're evaluating all the current orders because they are changing daily and weekly, which makes Imants and my job difficult, but we're staying up to date on trying to make sure that everybody's following that. So with that, I'll leave it to Imants.
Yeah, this is just something that we're going to be dealing with into 2021, and we're obviously making it a key focus of our webinars to make sure you're staying up to date. So tune in for more on that. It seems likely that we're going to have to go do a deep dive on exactly what the steps are process-wise to address issues both with commercial and residential tenants, and then obviously in each of the relevant sort of jurisdictions that we operate in. So look out for that, and we'll just keep moving and looking forward to some resolution of these issues as a vaccine comes out, obviously. So now moving into sort of wins and losses for the year, talking about sort of across our client base and our space, I would say key loss, obviously, COVID really shut down a lot of businesses. Certain businesses were just sort of dead in the water. Particularly restaurants that weren't doing carry out, a lot of retail space that were non-essential, and then a lot of projects that were teed up to really be going strong in that Q3 time zone, got delays, and we dealt with a lot of force majeure issues and tried to process those. Everything seems to be back on track in terms of development projects. That was a huge loss and a certain pause that occurred, and everything else that comes from COVID. A big win which is kind of making lemonade out of lemons, would be this whole online move with most of our businesses, including our firm, just immediately shifting to working from home for the most part where possible. And this has led to a lot of efficiencies that, obviously should be celebrated. Obviously, this webinar, we're excited to be doing this and have it so heavily attended. So thank all of you for, joining us and joining us in the future as we kind of move through figuring out how to get the best presentation of what we're doing out to our client base. Hamilton, you got a win and a loss for us?
Yeah, I think that wins and fails. My win is really kind of piggybacking off of what you said and for the year of 2020 is appreciating how good we had it before COVID and how good life was and is in it, but now in a different way. And slowing down has been a big thing for me and all of us. And that used to be running from meeting to meeting to evening event to morning event to breakfasts and lunches and luncheons and whatever the industry event it might be. Slowing down and connecting with family, clients, and colleagues, albeit in a different way, the virtually, has been, I think, a win. It's made you think and reevaluate exactly where are you spending your time. The biggest fail to me of 2020 is the government picking winners and losers. And that kind of goes with the moratorium that I was talking about earlier, is that they pick winners and it's supposed to be for the broader good, but there's no real guidance or support from the government when they pick a loser. When the government tells a category of business to shut down for the greater good, it provides them with no support. For instance, restaurants, you got to shut down and you can't do this, but no support on the back end. No, hey, we're going to pay your rent or we're going to pay your employees. It just says shut down and then they try and figure it out later. It's a huge miss on the part of government, which will have lasting consequences on a lot of small and medium-sized businesses. It's the same thing on the real estate owners, on the residential side in particular. No evictions, landlords, you can't evict, you can't, proceed to collect any debt, but the government doesn't give any tax or mortgage or debt relief. And ironically, no ability to protect their assets or their tenants. One thing that we've seen is that tenants are complaining about other tenants for legitimate, breaches of lease agreements where they're feeling threatened or they're feeling, that this person is going to be a safety violation. It doesn't raise to that immediate threat level that is in the moratorium. The landlord can't do anything, can't protect their own tenants in their own business. But the moratoriums have forced a lot of businesses to shut down, as Imants said. And it's been paralyzing for a lot of them. And it's been difficult for us as advisors to try and help get them through it. But we're doing the best we can, and we know all of our clients are as well. But the certainty is something that we hope we can see in the laws as we move into 2021. So I'm optimistic that that'll get there and the vaccines will really help.
Predictability, consistency in lawmaking, it's overrated, Hamilton. Move to a different city. Moving on to sort of the theme of today's webinar, year-end to-dos. And this is something that we talk with our clients typically at the outset of their new business. Hey, you've got this new entity or corporation. Here are some things you want to be doing regularly. We don't often we get calls to do, and we do have clients that want to set up a year-end meeting, and that's great, and that's something everybody should do. But we haven't typically gone through the whole list of things, and so this will be great. I'll start us off with entity issues. Hamilton will take us through some tax and then PPL issues. I'll go through some lease and insurance issues, and then Hamilton will talk about some estate planning or succession planning issues. On the entity side, obviously every year you've got an annual renewal. So that usually comes to your registered agent and you pay whatever the current annual renewal fee is. And that's just something that has to happen. If you fail to pay the annual renewal fee to the Secretary of State, they start sending you notices or your registered agent notices saying that you got to pay or you'll be administratively dissolved. I believe it's 2 notices. I could be wrong on that. But after 90 days of non-payment, then they will send an administrative dissolution notice and your entity no longer exists. So that's bad. It doesn't mean actually that your entity doesn't exist. It means that you are not properly registered with the Secretary of State, which is a requirement for forming an entity. But however, if that happens, you've got to a 5-year look back. It varies, I think, from corporations to LLCs, but I believe right now it's 5 years, within which time, if you call them up and say, hey, I was administratively dissolved, I want to pay my annual renewal fees, they'll do a little tally for you with some little bonus costs or late charges, and you can pay whatever the total dollar amount is, and they will reinstate your entity. You don't want to be in that world for a variety of reasons, and we won't go down that rabbit hole. You'd prefer to be properly registered each year. If you're a corporation, you must have an annual meeting. That's in the statute, RCW 23B. That's just a requirement of corporations. If you're an LLC, then this is one of the big reasons you are an LLC, or most people are LLCs these days. You don't have to have an annual meeting. It's not a statutory requirement. However, your operating agreement may say that the members are going to meet each year. If you have an operating agreement that says that, you should do that. One of the things that protects you as a business owner, one of the main reasons you're doing these entities is to protect yourself from personal liability. Well, one of the main reasons people have their limited liability veil pierced is for not failing the formalities. And what are the formalities? It's this annual renewal. It's following your operating agreement, which if it says you meet annually, you should do. And it's generally segregating your assets from the LLC and treating it as a separate business entity. What that means also about following the formalities is that each year you should take a look at what you've done that year. Any big material moves need to be documented in your operating documents, or at least in a resolution saying, hey, we did this and that, and it was approved by the members. Again, one failure to do that may not be the end of the whole entity in terms of that failure to follow formalities. But they will look, if you ever were in a piercing situation, they will look at a factors analysis of how many times did you just treat the entity like it wasn't even there, you just kind of did stuff. So each year, you probably do want to take a look back. And if you added or took away members, you do you document that in paper, you talk with your attorney about how to do that. And you update your minutes. If you're a corporation, you should have annual meeting minutes that document what happens at that annual meeting. And those should be kept all together in one spot. So you have them all ready if a lender or anyone else asks, heaven forbid litigation. Another question we get on the entity side is, hey, it's the end of the year. I just realized that this entity sold all of its real properties last Q1 of this year. What should we do now? And the answer varies. So you should talk to an attorney about this. But essentially, it's probably most likely one of two things. One is just you're going to let it administratively dissolved, as I discussed earlier with the renewal process. If you just don't pay the annual renewal, it will eventually get administratively dissolved, and it'll just be sitting there as a non-entity. The other way is called a winding up process under the statute, and in congruence with your operating agreement, you can wind up the entity. That is a process with a number of steps that I won't go into, but essentially you look at the liabilities of the company and you pay off all outstanding liabilities, send some notices out, and then you're officially wound down. The assets of the LLC are distributed. If you follow that process, you are much more efficiently completed as an entity. And the reasons you would do that is to, again, prohibit liability in the future, or at least mitigate the chances that you have personal liability in the future. There is personal liability if you incorrectly wind up an entity, because you're going to be the person distributing the assets. You can envision a situation where there are debts and liabilities of the entity, but all the assets have been distributed and there's been some assertion that the entity has been wound up. So long and short of it is, check with your attorney to see which way you should actually go on this and review sort of the facts and circumstances. Those are likely to be the two avenues that you're going to go down to wind up. Hamilton, did I miss anything on the entity front?
No, I don't think so. And kind of my next two topics also tie together with the entity and LLC issues. One being kind of accounting, while like on our outline it says CPA, but as you know, I am not a CPA.
It should be checked with your CPA.
It should be checked with your CPA.
We don't give tax advice.
There is no tax advice on this webinar or on any phone call with us, but you should contact your CPA. But from the legal side and the litigation side, one thing that in terms of the entity issues is making sure that, to Imants' point, you're respecting the corporate formalities. The biggest thing that people are going to try and dig into if you ever get into litigation is where did the money go? And did you properly expense items? Did you properly track it? Did it go into the appropriate accounts, et cetera? Or did it get distributed to, a different entity that you own, or did like a rent check go in the right place? That is going to be, it's very common. I see it all the time in litigation. And it's something that people just look for to try and pierce the veil so that you have some sort of personal liability in your litigation. So if there's something to be done at your end, is check to see what you did throughout the year in your accounting documents. Make sure that you're connecting with your CPA, check your QuickBooks, make sure that all the expenses and dollars went to the right places. I mean, and full disclosure, when Imants and I were young business owners, we also made the same mistakes we tell people to avoid. So it happens to everybody. It's not uncommon. Don't feel bad about it. Just make sure that you correct it as soon as you can.
Yeah,
so,
I would jump in and say, this has gotten much more difficult with the advent of modern banking online, where you can just slide money around, and it gets commonplace. You slide the money over, or you pay Jim or whatever, and nobody is the wiser. That's what Hamilton's talking about. You need to document, where the money's going and paper it wherever possible.
Yeah, if it's a business account, the business should, or a business expense, the business should be paying for it. Why are you paying for it personally? Or if it's a personal expense, why is the business paying for it? Vice versa. All of those kind of basic items. The one thing in a lawsuit that people will ask is, are you treating the entity like yourself, or are you treating it like a separate business? And we know we have plenty of clients that where this becomes an issue is, like, why were all of these trips put on your business account when they aren't tied to the business? So if that question comes up in a piece of litigation, Imants and I are kind of sitting there going, I don't know, was this just a shell corporation that really meant nothing? So anyways, as you head into the end of the year, make sure to check your accounting, make sure that loans are properly documented, personal loans to the corporation, if that required this year, which would not be uncommon. Make sure that those are papered, that they're reflected on your books, and that all of your dollars are straight on where they are, because that will help you if there is future litigation, and keep maintaining that corporate structure so you don't have personal liability. On the PPL, the payment protection or paycheck protection loans, the grumbling is there's supposed to be something announced tomorrow from Congress. Who knows? I'm not going to make a prediction there on what's going to happen. I do know that if you are considering selling a business or selling a portion of your business and you have a paycheck protection loan, that becomes an issue. And we're working with some transactions right now. I know Imants is, and I am as well, where this has become an issue. And really, this is a brand new thing. This PPL, the paycheck protection loans, this year. So the banks are still trying to figure it out. The SBA is still trying to figure it out. But if you are looking to sell your business and that is still on the books, it hasn't been forgiven or you haven't paid it back, this is going to be an administrative task that your the legal counsel and that your bankers are going to have to deal with. So if you are looking to sell, or if you're in the process of selling, just be aware that the SBA is looking at these closely. They are allowing it to transfer to the new owners, but only under certain circumstances. So, but it is an administrative task to just be aware of as you head into 2021. And with that, I'll turn it over for Imants on the lease side.
Yeah, so commercial, this is primarily commercial leases, obviously, where you have multiple year leases. And we don't need to go too far down the path for landlords that you have operating procedures that are in place. We'll talk about a few things on the insurance side, but especially for tenants, this is an opportunity each year to sort of have on your calendar as your annual to-do to check any leases you have. If you have multiple locations, take a look through what deadlines are coming up, particularly option renewals, renewal options to purchase. The notice deadlines, sort of commercially reasonable notice deadlines right now are out you have starting 180 days out and no less than 90 days in most cases. So you've got like a 3-month window. And if you've got a 5-year lease term, you can kind of skip right over that. And if you miss those, the courts have not demonstrated themselves to take that too kindly. You are a commercial business owner. You are sophisticated enough to be able to read your own documents. So they're going to hold you to it. So the end of the year is definitely a time where you want to check that out. The other thing that I tell people to look at is, especially if you've got a lease where you've been there for 5 years or more, some of the insurance provisions for what the denominations are might be a little light. And that's something that we'll talk about as well, as I move forward here. And you really just want to take a look, make sure everything's, dialed in and you're in compliance and you've sent the certificates to the right place. So there's no screaming breach from a landlord. On the landlord side, and this is talking more about property owners generally, each year insurance is a big piece. And you want to be checking with your insurance advisors. You obviously are. You get that infamous call or email on the renewals. But I think it's good at the end of each year to look at it and go, where are we? And if you've added assets to your portfolio, you may be at a point where it's time to take a look at different insurance advisors at different rates. The structures change dramatically once you hit a certain asset value, because you're able to take your whole portfolio and they'll do risk analysis on it. And basically it could shift your cost pretty substantially. The other piece is just, you've been going year to year with somebody that you've been working with, and you haven't been upping the coverages, especially as you pay off assets and you don't have a lender sort of chirping at you about, and rightfully so, about your insurance certificates. You should be working with a skilled insurance advisor to make sure you're well covered for the right things. If you're a business owner, your coverages are something you want to be paying attention to, and something that we talk about often with our clients, especially new business owners, is just making sure you have an umbrella policy. You've got homeowners coverage that covers you and your car. It's a couple $100 a year typically to add about $1 million. You may want more of coverage, and an umbrella policy is just everything that your other insurance doesn't cover. So as long as you have a primary insurance, and there's different requirements for this, I don't want to go too far down the rabbit hole. The bottom line is, we've had many clients who had coverage for $2 million for some business claim, and there's a $2.5 or $3 million type claim that comes in, and they were able to call their umbrella coverage in to cover that last bit, and they didn't face any personal liability. So definitely something to look at. Hamilton, why don't you walk us through some estate planning stuff?
Yeah, I was going to say both estate planning, and before I get to that, and estate planning and like succession planning on the lease too. Another thing that I'd like to just add in with Imants is to take a look and see if you do have any outs on your lease, if you're a tenant, or vice versa on the landlord side, if there are any outs for an early termination. And also if there's a rent increase that's coming in 2021 or in the near future, put those on your calendar. One thing that Imants and I have preached throughout 2020 is communication. Communicate between landlords and tenant to see if you can work together, and see if that is a rent freeze in terms of no increases, or maybe it's a lease extension. We've worked on a bunch of those where, hey, we can give you a break today on the landlord side. We're going to reduce your rent today, but you're going to stay in for an additional 5 years, whatever that might be. You can turn this situation, which is crappy for many people and for many small businesses and medium-sized businesses, is that you can turn a crappy situation into a good one where the landlord is happy and so is the tenant, but it all starts with communication. So on the leasing side, I'd say look for rent increases, look for early termination options, and communicate amongst each other. So those would be my 3 to-dos on the lease side, commercial leasing side before year end. On the estate planning, this one is easily and often overlooked by our clients is that, oh yeah, I had a will, I can't remember what it was. Well, what's happened with your assets? Have your assets grown to such a degree where now there's tax considerations that you needed to come into place? So, or have you had kids? Has somebody passed away that was a beneficiary on your will? Take a look, dust it off, see if there's any changes that need to happen. Or what we see often at the end of the year, if you don't have one, give us a call. We can help you out. Even a simple one. A simple one is something that we can put together pretty easily, and it's really important. And so those are my just tips on estate planning. And the last item that I'll jump into is just succession planning and gifting. which is again a very common thing to do. Looking at the end of the year, who knows what taxes are going to look like next year or the year after. I can predict with very high degree of confidence that they are going to be much higher than they are right now, considering the debt that the country and the state's taking on dealing with this pandemic. So taxes are going to go up. What are they going to be? I don't know. But if you're going to do anything with your estate or succession planning of your business in terms of, say, giving shares to children or employees, those are things you should start looking at and thinking about now. And really, as you're thinking about not only an estate or a succession plan in the business, what do you want as a business owner? It's really like, what are your goals? Hey, I want to give it to them. Well, that's too simplistic. It's, well, what is your goal? Do you want to be paid out for a period of time? Do you want them to just have it and not work? Are you anticipating that key employee stays and continues to work and pays you for rent? I mean, there's so many different considerations on the succession plan. Don't just give something because there's a tax reason to do it. That's a piece of it, but there's a much larger strategic consideration. And also, legally speaking, you want to make sure that the documents are right. So if you're going to do it for tax purposes, make sure that the documents are reflected properly so that you get that benefit, or that your beneficiaries get that benefit. Because if you don't, then the IRS could come right back after you. So with that, I'll leave it.
Yeah, so those are all great points. And I would just add on the estate planning side, we typically advise clients to create some kind of informational sheet in a secure way that guides whoever is your personal representative or executor, just where the money's buried, the accounts and all that. If you've made substantial changes to that and you're the only person that knows about it, that's going to make that extremely inconvenient during probate or processing of your estate. So be sure to make updates to that sheet if you keep one, and make sure somebody, preferably PRs, knows where that is in the event of your demise. With that, I think we can move into some Q&A. So if you have questions for us, and we've got a few already, just go ahead and type them in. And if we can get to them, that'd be great. We'll try and keep this brief. If you have questions afterwards, of course, you can always email us or call us. The first one here was, what do I need to do if we bought out one of the members of our LLC this year? And I can tackle that. If you had a new member come on, it would have been good had you done an assignment of membership interest document. It's just a simple 1 or 2 page document. To the extent you haven't, you want something signed that amends the operating agreement that states the percentages of the currently owned membership interests. If you have anything on the registered agent or on the Secretary of State website or registration process that has that member's name, you definitely want to get online and update that, and basically create the proper paper trail such that your bank or any litigant requests these documents in discovery, they're all up to snuff and you've, again, followed the formalities. Let's see. Another question we got was, when you say insurance advisors, what do you mean? Hamilton, do you want to take that, or? Sure.
Insurance advisors there's lots of brokers out there, and there's lots of specialists that can dive into your types of insurance. So insurance advisors are just like attorneys. They will review your policy. If you need some names, we're happy to send you some referrals. But insurance advisors, it really will depend on your industry too, because everybody says insurance and that's a broad definition, but there's categories of insurance. So you want to make sure that you're talking to your broker to make sure you have appropriate coverages for what your business is actually doing. It's something that Imants and I regularly do, especially on leases. We say, okay, send this lease provision to your insurance broker to make sure it's going to match with what the landlord is asking or what the tenant has. So you want to make sure that you're looking at those items.
Yeah, I would say that, there's a couple of different varieties of insurance advisors too. You have people that have been in the business for a long time and they're just very comfortable. And sometimes they can be like family members or close friends, unfortunately, and they're just not young and hungry anymore. And they're just collecting their premiums. And then there's another group of people out there that are real hungry. And what we've seen over the last few years is a couple of things. One, premiums can change radically, and be much higher or much lower. And it's extremely unfortunate to see a whole portfolio of real estate where they've had the same insurance advisor for like a decade, and they go to a new one, and it's like a big number delta in cost for the same exact insurance. Or we find out that they haven't had a certain type of insurance, they just thought they did. Another big piece is how involved the insurance advisors are in actually answering your questions from the attorneys. So when we do commercial leases, or even sometimes really complex purchase and sale agreements, we are, looking at those insurance clauses, and they say certain things, and we'll typically say, hey, cut and paste this whole section and send it to your insurance advisor for review to make sure you're actually getting that. Some insurance advisors will look at it and say, yeah, you're good. The response email is literally, that's good. You're good. Other insurance advisors will literally edit that language and send back edits saying, here's why this might not be applicable. We've changed this and that. Have your attorney take a look at that and asking questions. That's earning their money, okay? If your insurance advisor isn't doing that, then it might be time to take a look around. We've got a list of them that are great. Happy to pass that along, get in touch.
We've got a question about a trust being a single member of an LLC. Can that occur even if there's multiple beneficiaries? Idea being to keep the LLC as a single member.
I don't see any reason immediately that couldn't be done. It's just going to depend on the circumstances, but I don't have any problem with that.
Yeah, I think that it definitely can be done. And I mean, really the beneficiaries, it's the trustee is the who's holding the membership interest on behalf of the trust. So as long as the trustee has control of the trust, then the trust can own the entity, and the beneficiaries don't necessarily get to have any say in that. And they probably for good reason. It's probably why it's in the trust. So I don't see an issue with that. I certainly think that makes sense.
Yeah, we got another one here. What do we do if we want to change, or we have changed our business name? And this happens all the time too. This is kind of in conjunction with I wanted to terminate, I have this old LLC, can I use it for this new thing? So maybe I'll make this into two answers to two different questions. Changing the business name is really easy. Secretary of State website, first, if you have any questions, call your attorney, of course, but you can just administratively go to the Secretary of State website and type in your new name. You obviously want to document this, shift it in your operating agreement and other documents. Again, have consent resolution so that all the members have agreed to this, papering the trail. Can you reuse your old entity? The answer to that would be basically, or should you do it? That should really depend on how much liability that old entity has accrued. If you have an entity that you don't know kind of what it did, or you had a 10-year career of leasing out real property and it was 3 different properties, you probably want a new entity. You want to start cleanly and from scratch. Another reason you might want a new entity is because lenders typically will require a single purpose entity. And if they find out or hear of, or you declare that you were doing other things with that entity in the past, but even if you no longer own those assets, the lender will say, nope, we need a new one, or we need this affidavit that you now have. It's just you can eliminate a whole bunch of hassle in your financing world if you just go ahead and start a new one. It's not strictly, prohibited to just use an old LLC and change the name, but there are circumstances where you might want to go ahead and start a new one anyway.
Yeah, and to piggyback on that too, with the new name, it may be a DBA, and registering a new DBA doesn't necessarily mean you need a new entity. A DBA, you can register with the same entity, and a DBA is doing business as, and that just costs you $10 with the Secretary of State. And then it's on your business license that you have, your formal name, Holmquist and Gardiner PLLC, doing business and as HG, so there's plenty of ways to do that.
That is a great point. I agree. Okay, with that, I think we're going to wrap up. If you have any questions, our contact information will be available. This is also being recorded if you want to come back and look at this, or if you have colleagues, clients, or friends that are interested. We want to thank you for participating today. And I think we are sending out a little poll about what you'd like to see in webinars for the next year. But we do have some great ones coming up on, again, commercial insurance more in depth with an advisor. And we're going to talk about, I think, floodplain issues and other real estate issues early on in the year. And we definitely anticipate covering whatever ends up happening with the turmoil post-COVID in the real estate world. So thank you again, and look forward to seeing you in the new year.
Thanks, everybody.